We are delighted to have with us today Mr. Haziq Ali Khan, Advocate High Court and a renowned moot coach who has served as an adjudicator on several national and international moot court competitions. His areas of interest include international humanitarian law, public international law, and international human rights law. Welcome, Hazam. I want to ask you that how does the international legal regime, particularly international humanitarian law, play a crucial role in regulating the conduct of parties involved in armed conflicts within the context of lawfare?
Fine. So I think this international law regime is the most, I think, manipulated sort of. You can say the biggest victim of this lawfare is actually the international law regime, whereas the international law regime has taken certain measures in order to take care of such sort of manipulations and this molding of law and all. However, still the states are to some extent they do, you can say, succeed in manipulating it. For instance, if you talk about the international humanitarian law specifically, so there is something known as perfidy. That is actually the thing, when you use the law, which and then you manipulate it in a way that you actually take you do something illegal in the garb of following the law. For instance, if somebody who is not capable of fighting back, fine, he is not allowed to attack when we are talking about the IHL. Now, what if someone just tries to play a drama? He is just trying to just fake his death or his incapability of fighting, and then he just attacks that very particular person who has actually pardoned him or left him for that purpose. So that is known as perfidy. So there are certain measures in the law, but still, unfortunately, they are manipulated still. So yep, this is how it is.
Have your perspective on lawfare? Like, do you see it as a negative or as a positive thing?
Well, this terminology, this lawfare, is actually coined to you can say denote something negative, like when you try to manipulate the law in your favor, and you can actually achieve your ulterior motives. So that is where we just bring this terminology lawfare into play. But as far as my understanding is concerned, you people are more focused towards, I think, that how can we can use this lawfare positively, right? The laws are actually formulated in order to take care of those things, and then manipulating them makes it a lawfare. So I think so laws, just merely abide by the laws, wouldn't it make it positive? What do you say? Or you want to say that we may just polish the precautionary measures a bit more, we must amend them a bit more? Is this what you want to say, or what?
No, the point is we want to use lawfare or law as a strategic tool,
Fine.
not just for the manipulation,
Mhm.
for resolving matters as well, for resolving disputes as well. Like, you cannot
Mhm.
go out with weapons and you cannot do the war, you cannot do the battles. Instead, if we focus on legal stuff and if we focus on law and we use law as a strategic tool to resolve our disputes, it would be more beneficial and more effective than going for a traditional warfare or going for a traditional battles.
If you want to see a quintessential sort of an example of the lawfare was what America did in Iraq. Fine. So that was a pure example of the lawfare, that what they did is what they actually took the plea of the CWC and they just went into Iraq, because of course you must have gone through this convention on the ban on these chemical weapons. So they alleged Iraq of actually preparing some chemical weapons, and then they went into their territory. Then secondly, they manipulated Article 51 of the UN Charter, and then they went inside Afghanistan, fine, making a new doctrine, Bush doctrine, which we know of the preemptory self-defense and all. So the thing is, what I'm getting from your perspective is like you people wanted the way they are actually using the law to just serve their ulterior motives. Similarly, I mean, they can just manipulate the law or just, mold the law into the positivities. But what I think is that the very purpose of formulating some law is actually to take care of those things, to actually serve the positive purposes. For instance, if we want to just, say this, America did wrong, then definitely Article 24 is there to just, what you can call it, to protect that act of aggression against the territory of a state. So the thing is, what I mean, that's totally my personal opinion. Your opinions or somebody else's, they might differ. That the lawfare can be a positive terminology. What I think is that the lawfare can be somehow mitigated by actually, somehow making amendments, somehow rectifying the mistakes which we see in the exceptions, which are normally used by the states or even the individuals in whatsoever the context we are speaking. So what I think is that the you can say the exit holes or those escape routes, they must be somehow cemented a bit more so that they may not be manipulated. So that is what I think about it.
In the context of lawfare, how do armed actors exploit or bypass international humanitarian law to achieve strategic goals? And plus, can you provide a historical example of such instances?
Indeed. So one or two I have given in the first question as well. I mean, the very famous ones. Coming on to the individuals, you might have heard a lot, much about the acts such as what do the people do is now there are certain protected buildings when we are talking about the warfare. So what people do is they start doing like using those for the military purposes, and then what happens is that they actually get compromised or somehow they really sorry. Yeah, so they somehow got just get manipulated. Then again, this perfidy thing, misuse of the emblems and symbols. I mean, theoretically it is quite easy to see, like, everything is being, like, covered by the law, but practically things are quite different. And that is why while I'm teaching this IHL to the people, I face many difficulties in order to just to just let them understand that, okay, fine, this is something that exists, however the implementation is actually the problem. So I think that is the prime example of it. Then you can see the Palestine issue. You can see a lot, many of them. So these are all the issues, or the, you can say, examples that are, I think, commonly they can be seen in the world. So yeah, that is a sad state of affairs, by the way.
Lot of cases in which they use lawfare strategies, and those matters are and those disputes are resolved. On the other hand, there are a lot of cases in which they did not regard the law as such, and those cases are still unresolved. What would you say on this? Like, for example, South China, for example, South China case, and Jordan Israel water dispute case. Uh, and there are like so many examples I can think of. What's your take on this, Haziq?
Cases which are actually, almost known to everyone. For instance, this Kashmir issue or the Palestine issue. So the major setback which is there in the resolution of these both of the conflicts is that the states are actually not willing to abide by the rules and regulations which are there, but they are not implementing it. So I don't think that the law has something to do with it. The implementation has to. So that is the main problem. Now what happens is, now Pakistan, for instance, if we are talking about this Kashmir issue, now Pakistan keeps on alleging India, okay, fine, they are not following the instructions of the UN Security Council resolutions, while the India would keep on alleging the state of Pakistan for that. So I think that is where the problem lies. Similarly, when we go to the Palestine and Israel issue, the same thing is happening over there. That, okay, they are like, okay, fine, they shall first of all abide by the rules and regulations set for them, while the other party would go do the vice versa, right? So that is actually the problem when it comes to this. What I'm saying, the thing is, the law is there, but the implementation is not. So I don't think that it is actually the shortcoming of the law. It is actually the shortcoming of the will of implementing that very particular law.
International law is referred to as a soft law. There is no real implementation of international law anywhere.
Not necessarily. I mean, it becomes a soft law now when it is only persuasive. But in case of a treaty obligation or a UN Security Council's directive, then it is definitely binding. So it is not like a soft law in every of the case, but yeah.
Yes, but Security Council resolutions are also not followed.
Exactly. So
That
that is the
strictly.
point. Yeah, so that
Yeah.
is the point, but we cannot say that it is actually a soft law instrument. They are definitely binding. Now, if they are not being implemented upon, there are many lacunas, right? So that is what we are actually trying to say. Okay, fine, those lacunas can be somehow covered up. I mean, they can be implemented upon. Just as legislation आप लोग करते हैं, so you people can simply, pass the amendments the way, the there is a proper procedure for, like, even amending this UN charter, so you can of course do that even. So there are many things, but the main problem is actually not in the law, but in the politics and in the will of the state. So that is the problem. Now, this Security Council permanent members, they definitely have this veto power. So most of the times, what happens is they are mostly conflicting with each other. What happens is they just, simply vote veto it, or they will not just let it pass through. So that is the whole point. Na? So I guess, uh, I mean, the best part is, if you can just see, there is some sort of an implementation of it as well. If you have gone through this, the General Security Initiative, Global Security Initiative, I'm sorry, by China, they're amended after this 2012 President Xi Jinping. His initiative is actually in pursuit of this. That what he says is that, okay, fine, what we are going to do is we are going to implement the true letter and spirit of the UN Charter in the world. So what they do is they simply go somewhere, and what they start doing is they start implementing that. And that is why you have seen that China has never ever waged a war as such against someone. Fine, and of course the use of force is there in terms of every state, but the way, I mean, the other superpowers have been doing in the past, this might be the only example of a superpower who has actually not used the force the way the others used to. So there are some sort of, I mean, some good examples as well, but they are definitely very scarce. So the thing is, which I think that, okay, fine, somehow this political will shall be mitigated, and this, the will to implement the laws in the true letter and spirit is the key to this whole thing.
Can you provide a historical example of conflict where the combination of legal strategies and military tactics in the context of lawfare was used, and describe how it impacted conflict resolution?
I mean, a recent example of this Afghanistan issue. So, I mean, the longest war, I think, which America was fighting after becoming this superpower. I mean, apart from the Cold War thing, because that is actually not a conventional war. So that actually, came to an end after the Pacific settlement of disputes, which is actually a part of the UN Charter. So I think after suffering for those many years, this is what they actually learned, that fine. I mean, they have to implement the laws after all, otherwise it is gonna like and be counterproductive. And you must be knowing that how much of the debt is there on America, and how much America has suffered in all those years, in terms of not only the casualties, but financially and other aspects as well, even politically. And even the current debate has been triggered after that, that most of the people have now started thinking that America is no more a superpower. So that is how it is. So yeah, that is the most current example, and I think so the most understandable one as well, because you definitely must be knowing that mediation process was initiated and brokered by Pakistan, and then they have achieved some sort of peace in that region, apparently at least.
So would you say that lawfare is more, effective than traditional warfare?
No,
Would you
that
say
I
that?
what I think is that lawfare was actually um, curtailed by the implementation of the law in this case. The lawfare was used to get into the territory of Afghanistan, and in the end of it, they had to actually give up that stance which they were doing as a lawfare, and then they had to return back to the territory.
How do international tribunals and courts contribute to the enforcement of international humanitarian law and hold parties accountable for violations committed during lawfare campaigns?
They do. I mean, there have been examples as well. So when we talk about the states, so definitely there is only one forum, that is the ICJ. In terms of this IHL implementation, definitely for arbitration and other things, there are other tribunals as well. So for states, I mean, if you see ICJ, so there have been some 4 to 5 cases from the top of my head. The very first case, in fact, of the ICJ was of which had some traces of IHL as well, because that was the Corfu Channel case, UK versus Albania, then Nicaragua versus United States, then Palestine wall case, then the advisory opinion on the nuclear cases, then the DRC case. So all of these cases, the states were actually somehow held responsible, or like they were brought before the ICJ, for the violations of these IHL and all. And in terms of the tribunals, then of course everybody knows about the ICTY, then ICTR, the Nuremberg trial, the Tokyo trial. These all were the tribunals and those judicial bodies which were actually mandated to just prosecute the criminals and all. So that's how it is. And now this ICC has been established to just take care of the very thing that if somebody is breaching the international humanitarian law, then you simply can take them, prosecute them in ICC for the violations of the war crimes and all. So yeah, they do exist, but then again, the point remains that the implementation is something that needs to be improved if we actually want to achieve the goals which we have set after the World War II.
How do you address concerns that lawfare might hinder military operations and national security while also emphasizing the importance of upholding international humanitarian law?
Is the point that the laws are there which are restricting the means and methods of war. I mean, when this IHL, when we talk about this IHL, this is what exactly it says. That okay, fine. Now there are two regimes, definitely jus ad bellum and jus in bello. So when you are in jus ad bellum, fine, you cannot use the force. But when you have used it actually, now the IHL regime has triggered the jus in bello one. Now it is specifically made. It is a special law. This is what we basically teach people. That okay, it is a special law that has been designed, formulated for the special regime in which you actually have to just limitize the use of force. Now you have used the force, okay, that is fine. Now the regime has changed. Now IHL does not care about whether the use of force was legal or not. That is a separate regime. That is something that has to be discussed somewhere else. Now what IHL does is it actually limitizes the use of force. Now what it says is okay, you have to use the force but within certain limits. So there are certain principles then. So that is what we are actually saying, that if the implementation is there in the true sense, then there are going to be many of the benefits of it. You cannot attack the civilians, you cannot attack the holy compas, you cannot use the disproportionate use of force, you cannot use WMDs. So all these things are actually there in order to curtail what we call it, the superfluous injury and unnecessary sufferings. So that is how it is.
So you basically do agree that it should be a principle that is used to limit the scope of conflict, लेकिन उससे beyond इसको interfere नहीं करना चाहिए.
For instance,
just to protect civilians and limit किसी भी किस्म का conflict in that sense.
It is definitely there for I mean, for the Hodi Comba and the combatants are always protected when they are not taking part in hostilities as such. So definitely it is there. तो काफी elaborated है, well elaborated है. The problem only lies in the fact that कि वो उस तरह से implement नहीं कर पाते हैं लोग बस. Simple as that.
Alright, so the problem lies with implementation basically.
Exactly, the implementation. I mean, there are so many things जो कि हम पढ़ाएं तो लोगों को लगता है कि superficial है. They do exist. अब उस पर checks and balances का एक तो मेन इशू आ जाता है, फिर implementations का इशू आ जाता है. For instance, अब अगर आप ICC की बात कर लेते हो, so what happens in the case of ICC is कि the major perpetrators of all the crimes, so those who are actually definitely alleged for that sake, so to have committed the maximum crimes, they were the part of all of that debate and discussion. They got it formulated, Rome Statute बनवा दिया उन्होंने. They encouraged everyone. So almost all the states who actually came up were thinking that okay, fine, they are the criminals actually. And while they are sitting on the table, so I mean, why not? Should we be they were like, okay, yeah, they are also going to ratify it, but at the last moment, what happened is they actually got it ratified by every of the state, and they themselves they just left in between. So this is how it is. So that is how, I mean, that was I think so. That's
irony of the situation.
Irony of the situation, or that is actually this is, I think so, as one of the examples of this very lawfare thing as well. You just simply show something and then do something else. So this is how it is.
All right. And you just mentioned that the problem lies with implementation. Do you have any suggestions for how we can improve that aspect?
Yeah. So if you are talking about the international law regime, so the very first thing is that your state must be capable of having a say in the international sphere. So, and I think the incapability of a state is nobody's you can say a fault but the state itself. So when you are in the international sphere, I mean the way we belong to a state where we don't have any say. I mean we cannot just stand up in the UN and say something and that would have much of force as compared to the states who have actually something to say, and people are going to follow them in the I mean in the letter and spirit of it all. So the main thing is, first of all, when you are talking about the international sphere, you have to be this much well, I mean we call them the stronger states, or you can say the developed states. And the yardstick for current world, the contemporary world, is definitely the economy. So if you are economically stable, because even if you compare it with the situations of your daily life, Sahib, what happens is you definitely engage into the relationships, you definitely get into the contracts for the mutual interest. Is that so? You definitely cannot go to anybody and have a contract for nothing. So there are always mutual interests lying. So what happens is, when you are economically strong, definitely every state has some sort of an interest lying with you. So they definitely are going to listen to you. So when you would be aggrieved for something, so the not only yours but others' interests would also be at stake. So they definitely are going to follow whatsoever you are saying. So that is the major backlash, maybe, which we actually face in the international sphere, because and normally other states even. So what we do is, or what like the victims of which we are, is that we are actually dependent upon the other states, while what we should have done is, instead, that we should have made others dependent upon us. And we could have, we still can do, but the only problem is, we all know that. So yeah, that is how I think.
But then
Mhm.
wouldn't this make international law of developed nations or stronger nations per se? Because
Yeah.
mostly we see in developed countries like superpowers like America
Mhm.
pressurizing the more underdeveloped countries into situations and into different sort of decisions. So
Mhm.
would
Fine. So there is a very, you can say, popular saying in this regard. This is, if you don't like a rule, follow the rule, reach the top, and change the rule, right? So that is the thing. Okay, fine. If being a victim state, you don't like something, so definitely you cannot do anything when you are a weaker one. So definitely when you would be on the top, you can bring changes in the order, the way you can see China has done. So just compare the China of, you can say, 1980, even pre 2010, you can say 8. Fine. You compare the China of that day and today. So they are definitely, they have changed the status first, and now what they're doing, what they are actually implementing the UN Charter in the letter and spirit. You just some if you haven't not you have not by far, just go through the we call it GSI, this global security initiative of China. Just go through it and then compare it with the UN Charter. You would come to know, okay, what sort of a mindset they have. So, and this CPEC, this is actually an offshoot of that. So that initiative actually encompasses the whole world, and CPEC is just, you can say, a simple strand of it. So it is just an offshoot of it. So the major thing, which we actually most of us don't know, is something quite above, quite like it has got such a big umbrella, that it has such a big canvas for that purpose. So that is what you should go through, so you will come to know. So definitely that is how it is done, I guess. So
You just mentioned that one solution could be that states have a say or the states make their way to the top, right? But on the other hand, how do you think the international community responds to the problem of protecting human rights when state actors or stronger states or states that have power, they themselves use lawfare to suppress dissent?
Yeah, I think so. It has something to do with the answer I have actually given, for this previous question. It's simple. The thing is, if they are not doing something right, so two wrongs do not make a right. So I don't think that as a state just merely shall follow some wrongful practices for the mere reason that because other states do the same. So what happens is, I mean, even in the weaker states, we can see that they have some some stringent limits. They have got some sovereign say. So what they do is they do not violate some of their own customs and principles just because some stronger state is doing telling them to do so or something like that. Na? So it is quite subjective for that matter. But the thing is, still, when you have given up your stakes to someone else, man, like you have taken a lot of debt, so definitely somebody is going to have the terms of their own choice. So the things differ case to case in this matter. So yeah, this is how it is.
And what remedies do you think the international humanitarian law has for weaker states, like in issues like Israel-Pakistan issue, sorry, not Israel-Palestinian issue, या फिर Yemen issue है? What do you think are the remedies that we have under the international humanitarian law for the weaker states?
सबसे पहली चीज तो मेरे ख्याल से लॉ ऑफ न्यूट्रलिटी law of neutrality plays a crucial role. What happens actually is weaker states actually start, then again we discuss, they again start following the stronger ones for the reasons that they are dependent upon them. So what they do is they just start guiding them for something, and then they have to just give up their some sort of sovereignty. So the major thing is that law of neutrality को play करें. You just don't take sides when a conflict is going on. Now the major issue just Yemen का और आपका Syria का issue है. Initially they were not that much of a big issue. They could have been resolved, the way these smaller conflicts do. I mean, एक civil rebellion से start होने वाले जो conflicts होते हैं वो civil rebellion की तरह state security. What happened is that the states just started joining in order to take the sides. So what happened is then again it is yet again a lawfare. ठीक है जी कि some states started portraying.
Looking ahead, what are the key challenges and opportunities for the international legal regime, specifically international humanitarian law, in addressing the complexities and challenges of lawfare in the 21st century?
According to me, first of all, checks and balances. What I think is, I mean, the way technology has advanced, and even the weaponry and the techniques to manipulate the law, like the techniques to do this lawfare thing, the mechanisms or the defensive measures have not progressed the same way. So what I think is that the technological requirements, even for the domestic measures, we can see, for instance, I mean, this is just an example. Of course, I am not someone from a scientific background, so I cannot just give the actual technicalities of it. But the way we can see that in some countries, the policemen, they are they have this camera sort of a thing installed so that whatever the conduct they're doing, it is recorded, it is being monitored somewhere. So why can't it just happen in case of a soldier who is actually fighting, who has actually a restricted power to take someone's life? Why can't just we install something such with them? Why can't we just equip them along with not only the weapons but also the precautionary measures? So while looking at these affairs, what I think is that the states are a bit sort of reluctant in order to implement those, because of course the liability would be on the state in the end, and that is where I think this lawfare again come in to the play. So that might be some sort of a suggestion that the checks and balances and the defensive measures may be improved the way the other things or the lawfare is improving. So that might be a good you can say breakthrough in this field of implementation of law.
How likely do you think it is that it will develop and take its proper shape and form and progress the way it should? Without being, because you mentioned earlier when we started the interview that it is being used to manipulate the legal system in many ways by state actors, by politicians, and by other institutes as well. So, how, given the circumstances right now, what do you think, or how likely do you think it is that it will develop and progress the way it should?
I mean, this may be just you can say a hunch or something, but we are actually expecting a paradigm shift right now in the legal in the world order, and the stakes are going to be in the hands of those states. I mean, apparently, who have not been much fond of this. You can say lawfare. They are. I mean, they seem to be a bit more. You can say practitioners of this soft power instead of the hard one. So I think when the stakes will be in their hands, we can see some sort of a development in this field as well. Because definitely when the rulers, or you can say that the superpowers, they would be of some other attitude, you can say, towards the affairs. So I think so they would then try to bring up such ideas, and they would try to bring up such development. So for that matter, I am a bit hopeful for that. Of course, not quite quickly or something, but we can see that within a decade or so, there might be some good progress in this direction as well.